The vast majority of criminal cases are resolved through a plea. This is when the defendant essentially admits to committing the crime, and in exchange for making the admission, he's usually treated more leniently by the court. Now, pleas don't always work out. Sometimes they're unagreed. The prosecution wants one thing, the defendant wants another, and you go before the judge. And if the judge doesn't accept a plea that the defendant is on board with, then the whole thing is scheduled for trial and the plea just doesn't happen. Now, defendants are a little anxious during the plea because you need to go before the court and on record basically admit that you committed the crime. So it's important to realize if you tender a plea, first you have to admit to sufficient facts to find you guilty. But second, you need to realize that this can't be used against you at trial, whether it's the criminal trial that would follow if the plea deal doesn't work out, or even at a civil trial on, based on the same facts and circumstances. What you say during the plea cannot be used against you. The only exception to this is if you get up on the stand, the prosecutor can use it to basically contradict your testimony on the stand. So you need to keep that in mind. And one other thing to keep in mind, if you tender a plea, the judge who hears the plea is the judge who hears you admit to the facts. So this judge is basically eliminated as the judge for your trial, especially if you decide to go to a bench trial. All right, so keep that in mind. I've written a blog post. I'll put it in the description below.